All right, welcome everybody to the Accessible Web Podcast. This is episode 6, and today we are joined with Billy Lynch. So, welcome, Billy. Thanks for joining us today.
Hey, thanks for having me, Peter.
And we've got Paige doing ASL interpretation for us today. George, as always, thanks for joining. So, George, why don't you bust into this intro? Who is this guy, Billy Lynch, that's with us?
Well, a longtime colleague. I'm very excited that he was able to carve out some time for us. So, Billy Lynch is a fair housing civil rights accessibility attorney. Since 2015, he served as the Assistant General Counsel for Fair Housing Compliance with the U.S. Department of Housing and Urban Development. Prior to HUD, he served as trial attorney with the U.S. Department of Justice Disability Rights Section, where that's when I met him. For the past decade and a half, Billy has implemented and enforced federal accessibility and other civil rights laws through investigations and litigation in federal and administrative courts. He's focused much of his legal practice on ensuring accessible technology, handling cases related to accessibility of public and private websites, applications, mobile services, equipment, assistive technology, authoring tools, and devices under the American with Disabilities Act and Rehabilitation Act. He's a senior executive fellow of Harvard's Kennedy School of Government, received his law degree from Catholic University of America and a degree in philosophy from the college basketball powerhouse, Loyola University Chicago. That was hard because I'm from Villanova and St. Joe country, but he lives in Washington, D.C. with his wife, 2 daughters, and soon to be joined by baby number 3. All discussions is provided in his personal capacity, not on behalf of the U.S. government. Welcome, Billy. I'm really excited that we're here. The last time we saw each other in person was quite a while ago. I, with colleagues, bought a satellite truck into D.C. To link up with DeafLink, who we had on our other podcast, to try to show an example of emergency management response, providing interpreting services. And he was able to bring a colleague who was deaf and signed, and it was a fantastic time. Best time I ever had in a parking lot in D.C. So it was exciting. So how is life, Bill? And how do you feel about the legal landscape as it relates to accessibility and assistive technology?
Well, thanks. It's good to be with you, George. And I remember that fondly. One of the areas I spent time in was in emergency management and accessibility as well. And of course, there's a significant overlap with accessible technology there. So that was a fascinating experience, and I'm glad to be back to join you again today. So with the legal landscape, some people will say that it's unclear, particularly with respect to Title III of the ADA and the application of Title III, which prohibits discrimination by public accommodations in the web space. I've never thought it's unclear, and I'll be happy to talk through why. I think there's a lot of folks out there who would like it to remain unclear. But really, at the end of the day, I think businesses that fit within the category of public accommodations really should just be working to make their goods and services accessible. There's a lot of legal reasons for that, and of course, a lot of practical reasons and just good reasons to do so. And some of that has been thrown into a little bit of question. There was a case out of the 11th Circuit. It's down in Florida and Georgia area involving Winn-Dixie. At the district court level, a blind plaintiff was successful in convincing the court that Winn-Dixie was required in its online services, which were fairly limited but still services, that they were required to be accessible. Winn-Dixie appealed that to the 11th Circuit U.S. Court of Appeals, and in a 2-to-1 decision, circuit courts of appeals have 3 judges generally when they hear cases. In a 2-to-1 decision, found that Winn-Dixie was not responsible for complying with Title III of the ADA. This is a case that's in tension with a lot of other cases, district court cases across the country, circuit court cases. And what that does potentially is set up what's called a conflict in the courts. And when you have a conflict between different federal courts, it's the type of thing that the U.S. Supreme Court is interested in looking at and granting certiorari on. Now, there's still a chance that the 11th Circuit will hold what's called an en banc hearing, which means that all the judges of the 11th Circuit would get together and can reconsider that decision. And there was apparently a request to do that. There's been some amicus briefs filed by some fairly large advocacy organizations asking for that to occur. So it's still possible that the 11th Circuit doesn't hear that. And it's also possible that they would change their decision. If they don't change their decision, it makes it, creates this conflict among courts. I'm not sure that case is the case, someone would want to bring to the Supreme Court from the plaintiff's perspective. Winn-Dixie may choose to bring it to the Supreme Court. I don't know if that occurs. There's a high likelihood the court would want to hear it. A few years ago, there was a case involving Dominos that did make it to the court. And so, I think ultimately these things are going to have to get worked out through the courts. Congress, although there's been some legislation in Congress to kind of deal with some of the questions people have raised about businesses and their obligation to provide web access and other accessible technology under Title III of the ADA, hasn't gone too far. So it's probably going to work its way through the courts. But, ultimately, I'm confident that the courts will find that at least some parts of the web are covered by Title III of the ADA. We can get into other statutes and other types of entities if you're interested. Public entities, state and local governments, it's a lot clearer there that there's an obligation. But private businesses, I think things are still a little bit open-ended.
Yeah, we get a lot of inbound leads, as you can imagine, from people that run a small business and or even medium-sized businesses, and they've never heard of this. And one of the big things I have to do is kind of the main salesperson is get them feeling a little better about this. Just give it a positive spin maybe, so that they don't feel, there's words that get thrown around like extortion or, are these frauds? Is this the same as, are these guys trolls? Are these accessibility trolls? So there's certainly a ton of questions still out there in terms of what are the responsibilities of a business. Do I have to do this? And the other tough thing is, in absence of having that demand letter, having received it and having, being forced to deal with it, a lot of businesses just choose to roll the dice. It's, if they haven't received it yet, they kind of feel like, well, this company's never going to, or these law firms are never going to come after me. I'm too small, or I'm in an industry that doesn't matter. I sell cars, for example. Why does a blind person need to buy a car? So yeah, it's pretty crazy with kind of the gray area, I guess I'd say, that exists in the mind of most business owners. But it sounds like to your mind, there's no gray area at all. It's pretty clear, and they just need to fulfill their obligations.
I hear the concerns from business owners, and I recognize the challenges they face, and they've got a lot of different things they need to deal with. They got to run a business. That's challenging enough. Doing so, particularly in the context of COVID, that adds obviously another layer. A lot of state and local requirements that aren't always obvious. And then, you've got these areas where I wish it were clearer too. And I think there's some, I guess what I would say to the small business owner, and I've actually had a lot of these conversations personally and professionally with folks, is, don't you want people with disabilities as your coming to your business? Spend a little time educating yourself, because this stuff actually isn't that complicated. It seems pretty intimidating at first. Having known nothing about it, and then, educating myself about it. I think, obviously building an accessible website sometimes requires a professional to do that. But as far as providing services that are in an accessible format and manner, and trying to reach out to people with disabilities, that's not difficult. The other thing I would say is, this is the same argument that's been made in the physical space all the time. We don't have people with disabilities in our building. It's like, well, you don't have an elevator, so how could they possibly be in your building? And this is just the virtual, manifestation of that. And so I hear the concerns there. I think, to the extent that there's private entities out there going after smaller mom and pop stores, I think that's probably less common than larger organizations who have resources. The other thing I would say is that the ADA has built into it defenses, like there's undue burden in providing certain auxiliary aids and services. And so it's not just you have to do this or else. There's actually a bit more to that. So it would be much better if there were clearer guidelines out there with respect to private businesses. Unfortunately, that's not where we're at the same time. I wouldn't sit around and wait, because there's money to be made, and people with disabilities want to use businesses. And if you're the one that's accessible, the next one isn't. And not even as a legal issue, just as a practical issue.
So my understanding of Dominos is that they were the ones that tried to escalate it to the Supreme Court because they wanted to try to establish some clarity around this law. Is that the case?
So they did. So they took it from the Ninth Circuit, and they asked the Supreme Court to grant what's called certiorari, or cert. Oftentimes you'll hear. There's two phases in the Supreme Court. There's the court needs to decide whether they're going to actually hear a case, and then they decide the case on the merits. They never get to the merits if they decide not to hear it. And what Dominos tried to do was to create tension between the Dominos decision at the district court level with other insurance cases that have determined that in the early 90s that there wasn't coverage of insurance. So it's sort of like apples and oranges with the web. But they tried to set this up, and you'll see this a lot in the literature, that there's this tension between federal courts, because some say it applies to the web, particularly where there's a nexus to a brick and mortar facility, but there's these insurance cases, although there's some conflict among those. And they tried to set it up and say to the court, you need to resolve this because there's tension among the courts. But if you look deeper, there's not really, there wasn't until this Winn-Dixie case, a lot of tension among the circuit courts. And the main reason that the US Supreme Court will want to hear a case is if there's a conflict in circuits, like I was talking about before. Because what you have is some parts of the country saying, you need to do this, and the other parts of the country saying you need to do something else. Now, that's a little bit odd with the internet, since it's everywhere. There's a whole area of legal jurisprudence on that topic, and so it'll be interesting to see what happens in this Winn-Dixie case. I'm confident, though, that if you really look at the statute and what Congress intended with covering businesses, I think it's possible the Supreme Court might ultimately, in the right case, say something like, we're not sure about web-only businesses, but when it comes to your pizza place or your retailer, things that are clearly within the scope of Title III, and they have multiple ways of doing business. You can call them, which is terrible, right? You can go there, which is becoming less common all the time, or you can go to their website. And the way that Title III of the ADA is structured, it applies to all the goods, services, privileges, facilities, advantages, and accommodations that the public entity provides. It's really hard to say, particularly as the years go on with the expanse of the internet and all the things you can do, and with COVID, that it shouldn't be covered. I don't see that happening when the court really gets into it. I think the analyses that some of the courts have applied, it's hard to follow, and just, they're just not rational if you look at the statutory language.
Go ahead,
George.
In terms of clarity, do you think the ADA, the ADA, will encompass web accessibility, and also with the migration, hopefully, of web content accessibility guidelines, hopefully being part of ADA eventually? Do you think there'll be clarity, and ADA will have enough power to kind of drive people in businesses to have accessible web information technology?
Yeah, so that's an interesting question, George. I mean, and I'm just speaking as a private citizen, not as a government employee, and not based on any government information that I may have been exposed to over time. So what I would put to you is that the Title III of the ADA in particular, because the other parts is very clear, like Title II, you have to do it. In the employment context, you have to do it. The Rehabilitation Act, it's very clear that if you receive funds, you have to do it. 508, you have to do it. And of course, the standards are very clear there. In the context of Title III, though, the analysis is a little bit different. The way that I would break it down as a lawyer, I would look first is, do we have a public accommodation, right? One that fits within the 12 categories. So banks, retailers, movie theaters, traditional public accommodations. Then the next place I would look is, in their provision of goods, services, facilities, et cetera, are they providing full and equal enjoyment of those things to people with disabilities? It can be in a slightly different manner than it's provided to people without disabilities, but is it full and equal enjoyment? So that'd be the first stop I would apply. And so I think that standard is already there. If you can use the website of one of the public accommodations and you without a disability, then you don't have full and equal enjoyment if it's inaccessible if you have a disability. So that's the first thing I would look at. The second thing I would look at is there's in the structure of the ADA, there's a auxiliary aids and services and effective communication regime. And basically what the ADA says is that you have to take appropriate steps to ensure effective communication with individuals with disabilities. And one way of doing that is through the provision of auxiliary aids and services. If you look closely at the DOJ's 2010 revision of the ADA regulations for Title III, accessibility is built into that, and technology and websites, and it's discussed. Now, they didn't go so far as to add, WCAG 2.0, and of course 2.1 didn't exist at that point, or even 1.0. But what they said is you have to take appropriate steps to ensure effective communication through the use of appropriate auxiliary aids and services. Those are providing captioning, interpretation like we have here, through alternate formats, things that have existed for decades in the non-web, the non-virtual space. But then there are some expansion that occurs there. So what I would suggest is that the framework is already there. And if that's the legal analysis that's being provided to a particular entity, there's no question in my mind that they're obligated when they provide, let's say, a service to deliver food to your house, for example. That's clearly a public accommodation. You have to have full and equal enjoyment of the goods, services, facilities, et cetera. And then they need to take appropriate steps to ensure effective communication. So if they have how-to videos, ensuring that there's alternate methods for that. If there are photographs of various items, the goods that they're selling, or maybe the restaurants that people can pick things up from, those are the types of things that should be provided in a non-visual format, etc. So I think that framework's there. Now, to answer your question, do I think that the DOJ will ever apply WCAG as a regulatory matter? I don't know the answer to that. I think that's it's a challenging question because the concern will be, is this going to suppress any business activity by applying this same standard rather than this more flexible auxiliary aids and services non-discrimination standard? What I can say, as a remedial measure, and I know because I was involved in settling a lot of these cases and bringing these lawsuits when I was there, is that WCAG 2.0 AA was a remedial, a remedy to dealing with the discrimination, the lack of equal access, the failure to provide appropriate auxiliary aids and services. And so if there are organizations out there who are looking like, what am I supposed to do here? Using that as the standard and following, what's in those settlement agreements and those consent decrees regarding, how to comply, that's the roadmap to get there.
These auxiliary aids and services, is this how Accessibility and these overlay companies are trying to kind of get around I know you're talking as yourself and not for the government, but is this, feel free to not answer this question, I guess, but is this one of the stances that they're most likely taking when they're saying they can make websites ADA compliant, but all these people with disabilities are saying it's not sufficient, and when we look at a website using these overlay tools, they're most certainly not achieving WCAG AA conformance?
Well, I guess what I would say, I have not studied some of the overlays. I've heard of these over the years, and I've read about the one that you mentioned. I have not done independent study of how these work, but what I would say is, if a public accommodation or frankly any entity that is covered by a federal or state or local law that requires accessibility in this space is using an overlay, and the overlay does not provide effective communication, or it does not provide full and equal enjoyment of the goods, services, etc., I would say that the public accommodation is going to have some issues from a legal perspective.
Yeah, you just kind of piqued my interest with the statement you made on business flexibility, because there's also, there was a guy a couple years back that was starting to create his own web accessibility standard because he didn't believe WCAG was sufficient, and the WCAG people kind of, I guess the industry as a whole kind of laughed him out of the room a little bit. Like, what are you doing thinking you're creating another standard? We already have one that works. And then, certainly as there's been money flowing into this area, as these lawsuits have picked up and as it's become clear to any website owner without their head in the sand that they need to do something, there's certainly a lot of half measures that have maybe popped up. And it lets a website owner maybe be lulled into a sense of false security for a monthly subscription, and then they haven't really made their website accessible. They've just kind of created a veneer of accessibility that lets them wash their hands of it and go on to the next task. Interesting.
Why even try at that point, right?
Yeah, a lot of it's the salespeople, and a lot of it's uneducated customer base that people don't know where to start. They don't have any clarity around the law. So they just kind of do a Google search, hop on the first company, they see a website that looks very authoritative, and they listen to the sales guy and think they've done it correctly. So it's certainly an uphill battle as we try to kind of sell against that, because it's sold as just an all-in-one simple solution, and that doesn't seem to be the reality. I'm
sorry.
No, go ahead.
Yeah, I was just going to say, you raised an interesting thing. When I was settling cases involving public accommodations, Title III entities, one thing that became very clear to me in having a sustainable web access or accessible technology practice within the entity, and of all sizes, smaller entities, nonprofits, massive corporations that span the globe, was you couldn't just have automated testing. You couldn't just have expert testing. You really had to embed it within the organization. Otherwise, it's just not going to work. And, I think I would, this isn't legal advice, but I would highly recommend against selecting an organization that, it's sort of transactional rather than educational as far as how to make content really accessible. It's worth the investment. And once you get there, people with disabilities love it, right? And they're going to come to that business. If there are businesses out there just using these overlays and just sort of like putting a certification on their website, even suggesting that they're accessible and not really knowing it. I think back to 50 years ago, and further back, of like what message is that telling the people with disabilities about your organization, if that's the extent you're invest in it.
Yeah.
And what we've been putting a lot of effort to is community outreach, but not just community outreach, but developing UX testing by people with disabilities, who we have employees on board doing that. And we're finding that businesses are very interested in having that part of the testing also. And I've been a big advocate of how do we develop developers and make it part of the business process, as opposed to going back and re-engineering. Once we can bake it into the process, that's going to have a long-term effect. In terms of accessibility and technology, and we were talking about this before the podcast, how important do you think accessibility was in terms of education and outreach during COVID?
Well, I was reading recently the amicus brief that Brown, Goldstein, Levy filed in the Winn-Dixie case. Greg Kerr and I think Eve Hill authored that amicus brief on behalf of a number of organizations. And it's something I've been thinking about a lot too, just how acute the COVID pandemic has made the need for accessible technology. I mean, so just a little bit of a personal background. My dad has quadriplegia, and I got into the accessibility world because, of the barriers that we faced as a family, and barriers with, just things in the home, with transportation, employment, you name it. And everybody has these stories who has worked in accessibility, of course. And I just think about like how acute the pandemic has been on accessing goods and services. The technology has the ability to open up all kinds of spaces for people with disabilities, and can actually be life-changing. I mean, I think of, as a kid, my dad and I couldn't play a lot of video games together, but my daughters get to play video games with them now, which is amazing. And they get to, and just like FaceTime and, other, web conferencing. And now he can access virtually everything in his condo because of mobile apps. And of course, if those things aren't accessible for people who are blind, it's going to create a lot of problems. If we don't have devices in homes that, have alternate formats, so to speak, so maybe visual alarms for people who are deaf or hard of hearing, then there's going to be a lot of difficulty in accessing the built environment and really engaging. And so, I spent a lot of time over the past year and a half thinking of like, we've got all these web platforms. How much of an investment are some of these tech companies putting into accessibility, being able to, bring in the relay service when necessary, thinking ahead of ensuring that, when you have an interpreter, that you can see the full interpreter, interpreting for people who need that. And we're not, as we all know, I mean, the world has changed. All these tech companies are mandating, that they're just going from a from home environment. A lot of employers, the federal government's still trying to figure that out. And I suspect we're going to hear pretty soon about what that looks like. But we're going to be spending a lot of time in a lot of different places. And if tech is not accessible, instead of having that ability to really transform people's ability to engage in the workforce and to bring their talents and their skills into different jobs, it's going to exclude them. And I'm actually very concerned about how fast technology is getting rolled out, how quickly different updates are being made in the background. People don't even know about these updates to video conferencing platforms. And are there people really thinking about, is this excluding people who are blind, people who are deaf, people with physical disabilities who may use alternative methods than a keyboard and a mouse to be able to access the video conferencing platform? So I'm very hopeful. I've spent a lot of time thinking about it because I think there's a lot of real, there's a lot there that can really be transformative, but I'm as concerned about it.
So we looked at the Winn-Dixie case and kind of thought, oh God, this is awful news. But it sounds like it might not be the worst thing, because now we've created that tension. Now that exists in the courts, is that gonna, and it sounds like that might force it up to the Supreme Court. So let's just say it gets to the Supreme Court and they decide that, Title III does apply to websites with physical accommodations. What's next? Like, what level do they then go to Congress or the DOJ and say, you have to make a law, you have to put the regulations and the teeth into this? Or are we just going to continue to be in the same spot where it's a legal requirement, but people don't know about it and there's no clearly defined requirements or penalties or timelines?
That's a tough one, Peter. I wish I had the crystal ball.
Sure.
As I'm sure everybody does. I think we could game that out in a couple of different ways. My guess is, who knows what the court will actually do with this issue when it gets it. generally when they do make a decision, it's a pretty narrow decision, and it's not going to solve all of the questions. So, I know there was a lot of anxiety around the Dominos case and whether that was going to mean the end of accessibility in the web context. When I looked pretty closely at it, number one, I was convinced that the cert was not going to be granted in that case. Secondly, I also think that if there was a decision, it would be a very narrow decision. And so there's going to be a lot of questions that are still out there. You can see that in virtually every case the Supreme Court decides. It's not the end of the story. Things are constantly being raised. And I know that disability, if it were going in a negative direction, the disability community is going to be going to Congress. They're going to be going to, agencies that implement regs. One thing that often happens when federal law doesn't sort of like fill the sphere is they'll just start going to states. And we've seen a little bit of that. There are a number of states out there that are regulating this activity. And so it's not the end of the story. And so I would, if you're looking at the Winn-Dixie case as, maybe this is the case that's going to once and for all decide this, I wouldn't look at it that way. There's going to be more to that story after the fact.
Interesting.
Now, in terms of technology and our future, in terms of, and we talked about this earlier, of where people are not getting technology, not getting broadband, which affects education and everything else. What's being done now, if anything, to kind of level the playing field of getting broadband to where it needs? Because we saw some of the stuff advertised during mainstream of what different companies were doing to get technology to people that need it. But as a whole in the country, is anything happening at the federal level that might impact that and make that happen, or are we going in that direction?
It's not really my area, and of course I am only speaking as a private citizen and not in my capacity as a government official. I know that it's I've heard in the media that it's on the radar of many people. I think it's a big problem. I saw a map recently. I think it was shared by my council member in DC regarding broadband access overlaid with racial segregation in DC, and it's stark. It's scary, and if you look at the concentration of disability overlaid with minority concentration, overlaid with the lack of broadband access in people's homes, or being limited to mobile access that maybe is over a cell signal that's pretty weak. It's pretty scary, and if we don't do something about it, I think there's going to be a further digital divide there. That, going back to the COVID situation, I know just as a member of my community, was very concerned as to kids being able to get into the classroom. And I'm really, really concerned about kids with disabilities who are just totally haven't had the supports. The supports were never enough in the first place. I mean, let's be honest, in most cases. And, then they're, in their homes working from an Android phone that, has spotty Wi-Fi, and from 12 different apps that are confusing. And I mean, the past year and a half, like, what does that do for them? So I'm really concerned about this issue, and I hope that others are concerned too. I've seen quite a bit of, like I said, in the media about it, and I'm hoping awareness is raised about it, because we have to do something about it. I mean, in my personal opinion, I've always thought of it as the equivalent of a utility. And without it, people are going to be more and more just excluded from mainstream society.
Yeah, I'd love to see it start to get regulated like a utility. And Vermont, we have a very, I mean, it's same but different, but they're struggling here with just the rural communities and getting everyone online. And how do we first and foremost get everyone on the internet and kind of stop this digital divide? And then once everyone's online, or probably in parallel to getting everyone online, how do we make sure that everyone's got the tools to actually, I guess, leverage the internet to make their lives better? And it certainly goes hand in hand with the inequality issues that are occurring in this country, for sure. We've talked a lot about like federal law. Is there anything interesting going on at HUD or around housing laws and accessibility?
Well, I can't talk too much about HUD itself. That would be a separate conversation, and I could have that in a separate podcast.
Yep.
In the housing context, I have seen some interesting things develop with respect to, there's a lot of technology that's going into homes, of course, appliances. We've been living with smart thermostats for a long time, smart plugs, and all of the mobile apps and apps that go along with that stuff. And I think, and I know that there have been some cases out there involving things like touchscreen directories and information kiosks. So, I think it would behoove people to start thinking about accessibility in that context. I know some people are, but to really spend some time on the front end in design of how we can ensure that a blind person who comes to visit their friend at a building can do so. That somebody who spends time in their house and maybe they're a wheelchair user and they can't reach a high thermostat or something like that, that they can access it through a mobile app and be able to live independently. These are the types of things that I think we see in all the different contexts: education, transportation, going to a hotel, going to a courthouse these days. Virtually everything, touchscreens everywhere. And so it's certainly concerning that if folks are not thinking about accessibility on the front end, what that looks like on the back end. So now we're going to be good, as we know. So I think there's some really interesting things developing there. With everything becoming smarter all the time, I suspect that there's going to be a lot to really consider about accessibility in the home.
It's come up a couple times where people mention just as every device went digital that you lost a lot of the tactile. With a thermostat, you can kind of feel the range and put yourself where you want to be in that range. Or I don't know, an old television, you've got knobs and you can feel yourself flipping the channels. And how with everything going digital, kitchen range, you can turn the burner off, you can feel that button clicking on your dishwasher. And with everything going digital, we've really kind of lost that. But I guess hopefully we're in kind of a transitional period, maybe call it. And as things go beyond digital and become web enabled, that hopefully there's some. These manufacturers are thinking about this, like you're saying, and building it into a web application so that people can control it from the device of their choosing, whether it's their computer or their phone or a tablet or something, managing their whole house.
I think one of the biggest challenges with things like the Americans with Disabilities Act and maybe less so with the Rehabilitation Act and particularly sections 501 and 508 is that it doesn't directly apply to manufacturers. Mm-hmm. And so we have a lot of people coming up with great ideas, that a covered entity like a state or local government or a private business that tries to implement and use that thing in the marketplace creates problems for itself. And I think, it's really unfortunate. I mean, that's kind of how civil rights laws develop over time. Even though the ADA is comprehensive and deals with a lot of different situations, it doesn't get at the front end. And I think there's been a lot of, usually what happens, we saw this in the built environment 20, 30, 40 years ago, where things like gas pumps fit within the architectural standards of the Americans with Disabilities Act. Other, controls and operating mechanisms and shelving and, microwaves in a retail facility that's like a gas station or something like that, or, the various things that you might access in a hotel that the ADA applied to those things, and then manufacturers started to take note of that and say, wait a second, we need to build that into our stuff. And then when they started doing that, I think they became, they sort of cornered the market when they were doing that. And I think what we really need, and this isn't even really a legal point, it's more of a sort of philosophical perspective on accessibility. We need more people going into organizations and evangelizing accessibility in all kinds of different ways. One thing that I'm particularly concerned about that's emerging is the use of algorithms and machine learning and what that's going to do, not just based on disability, on the basis of many different protected characteristics. Machines are going to be learning from a data set that is flawed to begin with, and the outputs are going to be problematic, and people are going to make decisions based on those, and they're going to think that, well, the machine made this decision or gave me this information, so it must be correct. Mm-hmm. And I'm concerned that I'm not exactly sure how that all plays out, but I think it's coming, and I think it's going to be problematic in a variety of different ways. Employment, culling through thousands of resumes of people, particularly as we're all working from all over the place, and trying to decide who should get a job. How do we deal with the fact that people with disabilities have historically not been able to get jobs? And what does the machine do with that? And how do we build in that variable? I mean, there's a lot of concerning things that are out there, but also a lot of opportunity to think about fixes to them.
If there's no elevator, there's no people that are blind in the building. And, it's the same thing that you brought up earlier. Like, they're not going to be in that data set because we've excluded them from the initial build. And so, yeah, that's really interesting. And, to come back to your manufacturer point, that's one of the things that's really apparent to us as web designers, web developers, is it's one thing to ask, every Shopify merchant to make their website accessible. And Shopify's done a good job of creating a framework now that if you use their platform as a starting point, it's accessible as a starting point, and you just need to maintain that accessibility. So at least it's possible. But in the web world, the manufacturers are they're the content management systems or the platforms. And so until they start forcing accessibility, or at least providing, more maybe strong suggestions on stuff like, when you add an image, add an alt tag, or don't upload a video without closed captioning, until they start to really kind of guide, maybe even force their users to create accessible websites, it's just not going to happen. They're the same as the manufacturers. They're kind of the ones that need to fall into place to actually make this happen at scale.
100%. I had this really interesting case when I was at DOJ, and there's a settlement agreement involving this organization where they produced, it was a nonprofit, and they were a MOOC, massive open online course provider, and so they had a platform where professors would generate, coursework that people could take, and what was so fascinating about working on this case, and I've had similar experiences with other organizations, is we started working together of like, what's the best possible scenario for accessibility for this entity. And we built into the infrastructure of this MOOC system, you would have to provide alt text for images. Right. You would have to upload a transcript for, which is not difficult to do with automation and people on the back end fixing some of the captioning, but embed that in there. Accessibility was baked into the infrastructure. And some of these organizations, like you're talking about, that maybe they are a massive organization where people can sell and buy things and have them delivered to their house, name unknown. If they really spend a lot of time focused on accessibility and forcing those organizations to do easy things, right? Like, it's not, and I mean, just the simple thing of adding alt tags to images, it increases their web presence, if anything, right? Like, it's not just for accessibility. There's a lot of benefits to that. They can use that data to sort things and to find, it's a data point that the organization can use. So there's a lot of other benefits that often work from a business case. But yeah, I mean, I think there are some good, actors out there. I mean, obviously I've always been impressed with Apple's work in this area, and particularly in forcing accessibility in mobile applications to a degree. I think there's a lot that can be done by those sort of like content management folks that can really force things in a good way. And I hope that continues.
Cool. All right. Well, we're just about at time here. So let me, we got a t-shirt to give away. Let me pull up my Slack. So for anyone watching, we are giving away free t-shirts every podcast to someone following us on LinkedIn. Today it is Riley Seith. Hopefully I'm pronouncing Seith right. So Riley, get in touch if you're watching, and if not, we'll track you down and mail you a t-shirt. If anyone out there wants to follow us, we're pretty easy to find. Just go on LinkedIn and look up Accessible Web, and we're also pretty active on Facebook and Twitter. And yeah, Billy, thanks for joining us today. This has been really informative. It's kind of put the Winn-Dixie case in perspective quite a bit for me. And the Dominos case, I guess. I'm by no means a lawyer. So, even talking in non-legal terms necessarily, it's really helpful. And yeah, just generally, thanks for taking the time today.
Well, I just play a lawyer on TV, so I appreciate you having me, and it was good. It was fun talking shop with you, and it's exciting to get to talk to folks who work in this area, and there's a lot to be done, but it's all great stuff. So really appreciate it, and hope we can stay in touch.
Yeah, I just want to thank you too, Billy, that I've been an evangelist in this area along with you for a very long time, and you've always been there when I've reached out with big or crazy ideas, and whether it's a satellite truck or anything else, you've been supportive, and that's why I'm so excited about being an Accessible Web. I'm finally doing it full time, so thank you very much, and yeah, we'll definitely stay in touch.
Cool. Well, thank you, Paige, as well, and for anyone watching, tune in to our Facebook page, and we've got more exciting podcasts coming up. So, looking forward to doing more of these, and subscribe, and we'll be back next week. All right, later all.
Take care.
Thanks, Billy. Thanks, Paige.